Hi, everyone, and welcome to the fourth webinar for those who've been invited to submit final applications to CLEAR's Digitizing Hidden Special Collections and Archives, Amplifying Unheard Voices program this year. I'm Sharon Burney, Program Officer for the CLEAR's grants team, and today's session will be focused on rights, ethics, and reuse.
Before we get started with introductions to the platform and our presenter for today's webinar, we want to launch a quick poll to gauge how you're feeling about today's topic. Thank you so much for filling out this poll. Okay, thank you so much. It looks like we have pretty much everyone that has filled it out. Thank you so much. Now, here are some notes about using Zoom during this session. A live transcript is being generated if you'd like to utilize it. To turn on this feature, click the CC Live Transcript button at the bottom of your Zoom window. Attendees will be muted throughout the presentation. However, you're welcome to use chat for general introductions and conversation. If a chat box isn't already displaying on your Zoom screen, you can hover your mouse toward the bottom of the screen and open it manually. In order to send a message to everyone, remember to change the default from all panelists and hosts to everyone. We ask that you use a separate Q&A box to ask questions. This can be opened the same way as the chat box. Because we have limited time together, please feel free to follow along with questions as they come in and upvote them to let us know that it would be helpful to you to have them answered live. We will do our best to answer all of the questions live, but we will also share responses to the questions alongside the recording. This session is being recorded. The slides, Q&A, recording, and transcript will be available on the Apply for an Award page of our website in the next 2 weeks. Before we move into our program content, we would like to center today's conversation by acknowledging that as residents of the U.S., we are speaking to you from unceded land of many indigenous people. We recognize the longstanding history that has brought us to reside on this land, and we seek to have greater understanding of our place within the colonial history. We denounce any acts of terrorism, colonialism, and environmental disregard, both past and present. In particular, we would like to respectfully acknowledge and recognize the original and current caretakers of the land, water, and air where we live, and all indigenous people and all their ancestors and descendants. I am grateful to have the opportunity to live and work on their homelands and ask you to join me in acknowledging all their communities, the elders, both past and present, as well as future generations. May this acknowledgement and our ongoing work demonstrate CLEAR's commitment to beginning the process of working to dismantle the ongoing legacies of settler colonialism. If you haven't done so already, we'd love for you to introduce yourself in the chat and share a land acknowledgement for the area where you live if you'd like.
For today's session, our host will dig into rights, ethics, and reuse. We've allotted 90 minutes total for today, and the speaker will pause at the halfway point at 2:45 p.m. Eastern for a quick break during their content. We're hoping for an engaging time of conversation around identifying rights and ethics and concerns in original materials, assessing risk, and determining appropriate access with creators and community in mind. The plan is to reserve about 25 minutes for Q&A near the end of this session. Both the session host and CLEAR staff will be available to answer questions at that time. So while you may pose questions throughout using the Q&A box, keep in mind that we won't get to every question as it's asked. Staff will be keeping track and will circle back to any unanswered questions during the dedicated Q&A. In today's sessions, you'll learn more about the skills and strategies you need to complete the following application task: the project details, rights, ethics, and reuse task, along with the upload, rights, ethics, and reuse appendices.
Now we're happy to turn things over to Sandra Innemel, the Program Director for Scholarly Communication and Information Policy at Yale University Library. So we'll take just a few moments to let Sandra share her slides and get oriented. And as they do that, please remember that we'll be breaking for 5 minutes at the halfway point, approximately 2:45 p.m.
Okay, hello everyone. I'm really happy to be here. My name is Sandra Aya Innemil, and I'm the Program Director for Scholarly Communication and Information Policy at Yale Library. I have also served as the last few years as a grant reviewer for many of the grant applications that come through for CLEAR. And so I wasn't able to participate in that way this year. So I'm happy that I was able to participate in another way, and I'm really grateful to be here. Hopefully we'll be able to get to many of your questions, but and I'll do my best to hopefully maybe answer them before you get to them. So we'll see. But please, feel free to start popping your questions in, especially if something triggers a question as I'm going through my slides. So today I'm going to talk about this very important section in the application, rights, ethics, and reuse, and going to go through what copyright laws and what other types of rights and issues that might be of concern for some of the collections that you might have. But first, a little brief short disclaimer. I am a lawyer, but I'm not your lawyer. So I'm providing information about legal topics and information so you can understand more about what things you might want to consider as you're putting together your application, as you move forward in collecting items, as you want to digitize or preserve this content, things that you might want to think about and consider. And hopefully things that will be helpful as you complete or are completing your applications for the grant. Also, I like to make sure that we're all on the same page of what we're talking about. One of the main issues at play here is copyright law. But sometimes folks get things a little bit jumbled when they're thinking about intellectual property rights as a whole. And so I just want to make sure people know what space we're working in. So trademark is the reason why you recognize certain brands, why you recognize the golden arches, why you recognize the price tag for Best Buy, the target for Target, like I have here. Patents cover processes, new and useful discoveries or improvements. And these are certain things that you might see. A recipe could be covered by patent. Certain ideas may be covered by patent. And trade secret are processes, formulas, and things that are not necessarily known and may be the secret to why your business is successful, and something that you wouldn't want others to be able to discern, even though like now with the internet age, there's so many things that used to be a secret that we didn't know what it was, and now we do because somebody investigated or found out, and then they put it on the internet. Copyright is the main focus of many of the things I'm going to talk about today, but it is talking about the protection of the expression of ideas, expressions of original works of authorship that are fixed into a tangible means of expression. And so that's going to be the main focus of what I talk about in terms of rights today, but I would be remiss if there weren't other elements that might also come into play. So issues around privacy, cultural heritage are also things that I'm going to touch upon today. So there's a long history of copyright, as many of you know, and we talked through and talked about with the land acknowledgement that we are on colonial property, and our history with copyright comes from the former colonizer of this country, which was the United Kingdom, England. And so 1710, we see the first copyright law, Statute of Anne. And this is a right that is created. So it's not a property right. It is something that is for people who are writing content so that they would have protection over their works for a certain amount of time. And then at a time that protection would expire. At the time, 1710, it was 14 years, and then another 14 years if the author was alive. So this is like just an important little tidbit to keep in mind for later, because we're going to talk about what term is now. And things that you might want to consider for the things that are in your collections of understanding when copyright term might expire, when you might have things that are in the public domain, and how that might impact your ability to do certain things with the content. So this is also where the public domain it comes from, because when rights expire, things go into the public and are publicly made for others to be able to use as well in their creative endeavors. It's kind of creating this balance between authors and users of content. In 1886, the Berne Convention came about as a copyright treaty. That time, the US was established, had been established for over a century, but did not join the Berne Convention at this time. And get to that in just a moment. In the United States, one of the things that the discussions that were happening around the time of independence from the colonizer nation of England at the time, United Kingdom as we know it now, they had wanted to have a similar law to protect the rights of people who are creating content. And so essentially they looked at the Statute of Anne and said, that looks good, let's kind of use that. And so we have a copyright law that goes into effect here in the United States in 1790. So one of the first acts that the founders of the United States of America wanted to do was to make sure that there were protections in place for creators of content at the time, mostly just thinking about people who made authors, who made books, who made maps. So those were the kinds of things that they wanted to have copyright protection for and make sure that those works were protected. Again, in the US, it was the same thought process of having protections for creators, but also something that's available for the public. So the thought was that the creators would have an opportunity to have the rights for a certain amount of time. And then once that time expires, everyone is able to make use of that to continue creativity moving, because it was recognized even then, and it's recognized now, that people have inspiration from all elements and aspects of creativity. So we might see something somewhere and be inspired by it. And then in this case, when something goes into the public domain, we can make use of it without having to pay for it. We can make use of it because now copyright term has expired. So just to go through some things that have happened in US copyright law. So we have 1790, the first Copyright Act, 1831, 1909, 1976, 1998. More recently, 2018, 2020, things have happened. You can see that there are some large gaps there, some larger than others. And with each element and each time in those earlier parts, like 1831 and 1909, 1976, more things came under copyright protection. So you'll see that photography came in 1831, 1909, we have film, and then there's all these elements and things that didn't have copyright protection before, with a new law, now have copyright protection. And 1976 is when we committed to fully join Berne Convention. And once we joined the Berne Convention, again, this is almost 100 years after it had gone into force, and again, an international convention. Many other nations had joined prior to that. We joined it, and so that made the our copyright term, life of the author plus 50 years. So that's the minimum term that's available through the Berne Convention. So most of what happens with this international copyright convention is that everyone is agreeing that each country has their own individual copyright law, and everyone agrees that they will respect the rights that are afforded under each country's copyright laws. Some other things of note that have happened recently: Music Modernization Act, which is trying to align sound recordings with federal protection. Prior to 1972, sound recordings were under state law. And if you've ever tried to look up state copyright law, you can understand how difficult and challenging it could be to determine what rights are in play there. And so now this was an attempt to get all of that protected under federal. It also created a public domain for sound recordings as well. 2020 brought a small claims tribunal. It's a voluntary tribunal which has a limit of $30,000 for mostly smaller creators, mostly like photographers who want to bring copyright claims but are not able to do so at the federal level. So I already mentioned a few things that can be copyrighted. There's an illustration here that shows audio, architecture, literature, video, film, choreography, music, drama, software, photographs, graphics, sculptures. These are things that are meant as a floor of things that can be copyrighted. There are things that may be not captured here that could still have copyright protection. And the key is that whatever it is that is created must be fixed in a tangible means of expression. So right now, this presentation is being recorded. So the recording will have copyright protection. The presentation itself is fixed in a PowerPoint, so it also has copyright protection. And so these things all have copyright protection and they're able to have copyright. So the important parts of this is to think about, times when things do not have, they weren't recorded, they weren't fixed into a tangible means of expression. So if we were not recording this, there would be no copyright in me just speaking to you. The presentation would still have copyright, but there would be nothing that's copyrightable that had been, if it had not been recorded. As a creator of content or as someone who is a entity that is collecting content, it's good to know what types of rights are available to people who create content. So you have the right as a creator to reproduce, prepare derivative works, distribute that work, publicly display and perform, and also publicly perform via digital audio transmission. So these rights are exclusive to creators, and these are rights that they can either transfer to others or license to others. They can authorize others to act on their behalf. But as the rights holder, they are the first person who has to be contacted, who has to be engaged in order to exploit any of these rights. Things that are not protected by copyright. So works that are not fixed, as I mentioned before, ideas, facts, principles, discoveries, systems. So discoveries or systems could be covered under something else, but they can't be covered under copyright. Works of the US government produced by the government, by government employees in the scope of their employment cannot have copyright protection. This can get a little tricky when you think about consultants maybe working for the government. So it would be important to know like their role. If any of you are coming from government entities and have anything that was created by consultants, you want to check and see what the arrangements were for copyright for anything that was created by the consultant, because it doesn't automatically become in the public domain if they don't have that already in place. And then things that are in the public domain, either because copyright term has expired or formalities were not followed. And I just like to pause here to talk about this slide from Dr. Kimber Thomas, who talks about what happens, what we should think about when there are certain things that are not or cannot be covered by copyright. So there's certain things like traditional knowledge, traditional cultural expressions, cultural designs, folk dance, those types of things that can't have copyright protection. And I mention them here because some of you may have things in your collections and things that you're wanting to submit for this grant that might fall into this, that don't necessarily have copyright as the issue of concern. There may be other issues related to cultural heritage, related to how you are making things available or making things accessible. But this is something that I always like to have people just think about in terms of copyright and what is protected and what is not. And it's not for me to say whether they should be or they shouldn't be, but I just like to have people think about that. I'm going to talk about the public domain. Many of you may not have things that are in the public domain, but in the event that you do, or you work elsewhere where that might be important, it's important to know when the public domain might impact how you're able to use content in your collections. So the public domain is as a term of art, a legal term of art in copyright, and it doesn't mean publicly available. So you're able to find something or find access to something online that is publicly available. It's not necessarily publicly in the public domain. So if you find something, on Facebook, something on Instagram or wherever, where have you, you might still think, or you should think, that that item, that material may still be covered by copyright, even if you're not able to immediately determine who the rights holder is or when it was created. That work may still be covered by copyright. I have a image here of Night of the Living Dead. It's an example that I like to give of when something goes into the public domain immediately. This is because at the time this movie was created, there was a requirement under US copyright law. You saw all the different times that things changed in US copyright law. There were different formalities that were in place here and there. And at this time, the formality was that there needed to be a copyright symbol with the name of the creator, producer in this case, um, listed within the film. At the time when they released this film, they did not include a copyright notice, so the work went into the public domain immediately because it needed to have that requirement in order not to. I also love sharing these images from the Center for the Study of the Public Domain at Duke that shows every year when content goes into the public domain due to the expiration of copyright. You might, in some of the work that you do, may be used to hearing the number, the year, 1923. And 1923, as in most things published before 1923, those works are in the public domain if it's published in the United States. The year now is 1929. And if you look at the graphic, next year, works from 1929 will be in the public domain and earlier. And then the year after that, works from 1930 will go into the public domain, and on and on and on. And it's going to go on this system until it catches up with our current copyright practices. So current copyright practices under the Berne Act is part of our joining the Berne Convention. Certain things like formalities like having to register your copyright, having to renew copyright, having to have a Circle C with your name and information as a copyright statement. Those certain formalities are no longer in place for the Berne Convention. They removed the formalities. These are all things that you can still do and continue to do, but you don't have to in order to have protection. So trying to figure out when something falls in the public domain can definitely be challenging. So now, as I mentioned, anything published in the US prior to 1929, so anything from 1928 and earlier is in the public domain in the United States. But there is what I refer to as a kind of black hole period, 1929 to 1977, where there are a lot of different things that are in play, a lot of different formalities that are kind of working together, going together, where you needed to register, you needed to renew, you needed to have notice, you need to have this, a lot of things that were happening at that time. And so how you would figure out between 1929 and 1977, what's happening with content, if you have things in your collections from this time period and you want to know, is this stuff in the public domain or not? You would have to do some research to try to figure out, like, did they follow whatever formality was in place at the time? 1978 to 1989, there are some other conditions that are applying. We are trying to make sure that we're in line for joining the Berne Convention. We're also, there's also some other issues that are happening as well, where there was thinking about making sure that we're able to do this. We also wanted to change terms from what the Berne Convention has as a minimum. So now our term for US copyright law is the life of the author plus 70 years. So then some other research needs to be done for that time period. And then March 1, 1989, we are on the schedule for Berne, where there are no formalities that are required. It's life of the author plus 70 years. Corporate or anonymous or pseudonymous authorship is 95 years or 120 years from creation, whichever is first. So there's, a lot of things to think about. Things that are after 1989 are a lot more straightforward because we're now fully part of Berne, and we can move forward in that way to know that what the term of copyright is. Who is an owner can sometimes be a little more complicated than you would think it would be. Usually it is the author who creates that work. They would be the copyright owner. But an exception to that is works made for hire. So when people are doing work as part of their job or part of a contract, they've been hired to do a certain thing, that work may belong to the person who commissioned the work or their employer. In academia, for any of you who are coming from academic spaces, there's also an exception to the exception because in most academia, due to wanting to have freedom of expression for faculty members, most institutions either outright give back copyright to their faculty authors, or they never make a claim towards copyright for faculty scholarship. And this is really due to wanting the faculty to do and write about whatever they'd like to write about, but also because they don't need to then manage any of the rights. They don't need to manage their publications or anything like that. And the faculty members are able to do that. Copyright can be held jointly. You can do transfers or assignments of specific rights or all rights. It can be impacted by institutional policy. So knowing what your institution says about that is important to know. One thing to really to point out as well is ownership of copyright is distinct from the ownership in the material object. So in some of your collections, you have the physical item. That does not mean that you have copyright. So you want to understand who is the rights holder if it's not you. And then if you have been donated items where maybe the rights were also donated to you, what are the limitations? What's the explanation? What's the information about those rights that were donated to you? And how are you managing those rights if they were donated as well? So we talked about this, but copyright is automatic. You receive protection as soon as something is fixed into a tangible means of expression. Under our current system, you need to do something in order not to have copyright. So you need to say, I disclaim all of my rights. You can use systems like Creative Commons, which has a CC0, not license, it's not a license. It's just a badge you can put on to say that you're disclaiming rights in that content. You can also put markings to say that this is when you own copyright in that material. This is something that you can do. You can also, as I said, you can follow certain formalities. If you're interested in copyrighting something that you created and you own the rights to, you can register that copyright. You can also put Circle C if that's helpful or useful for you. We talked about the duration of copyright here, but I want to talk, also about duration for sound recordings. For some of you, this may be important to think about. So with the Music Modernization Act, part of this new act brought in sound recordings to try to provide some information about the public domain and also the terms of copyright. And so establishing that was really important. And it was really awesome that this year is the first year, 1923, and earlier sound recordings are in the public domain. And so you can see from the chart here that there are some tiers to when these works will eventually go into the public domain. Again, once this is done, they should be caught up to be with a part of the regular system that we're on now, which again is life of the author plus 70 years. So all of this to say, fixed and tangible means of expression, you can have copyright protection. You own the work unless it's created as work for hire. It belongs to you unless you transfer that work. Things that are in digital form on the internet are also tangible, covered by copyright. And rights, it seems much longer than 14 years at this time, but they do eventually end. So now to talk about using materials in your collections. There are several copyright sections that aid cultural heritage institutions. Some of you may be familiar with fair use, Section 107, reproduction for library, Section 108, first sale doctrine, which allows libraries to function in being able to purchase and loan out materials for others to use. Classroom display and performance, which allows the use of copyrighted materials in um, face-to-face academic or teaching settings, or in certain very limited circumstances, online distance learning circumstances. So why does this matter? There are criminal and civil penalties for this work, and I hate to be the heavy here, but it is important to think about, especially as some of this content you might be interested in making available online, openly, or even through authenticated services. But you might want to think about these things and think about how you're using the content created by other people. The context of the use matters. So I mentioned this section 110, which is the classroom and teaching exception. So when you're face to face and teaching a class, if I were in the same room with you all, I could do all kinds of things. I could show you a film, I could show you books, I could even perform Beyonce or something. You wouldn't want to hear me perform Beyonce, but I could, right? Because we're in a face-to-face session. But because we're actually not face-to-face, we're together digitally, there are a lot of limitations on what I can actually do in this space with you. And this is due to copyright law and due to the limitations of how we're able to make content available to others. So again, like I mentioned, if you're planning to make things available through the internet, if you're planning to even make things available, maybe not openly, but through a closed service, there's still considerations that you want to think about and how you might be able to do that. You can always ask for permission from the rights holder to figure out who the rights holder is. And remember, you want to think about, is it the person who created it? Is it their employer? Is it someone else? And then think about what it is that you want to do with the content. Do you want to put it in a book? Do you want to put it in, on a disc? You want to put it on a blog? What is it that you're trying to do? And if you're able to have verbal conversations with the rights holder, the appropriate rights holder, might want to try to make sure that you get that in writing, sending an email to say, just to recap what we talked about you allowing me to do X, Y, and Z with your content. I just want to lay out here what it is that I'm planning to do, and to make sure that people, that the user, the creators of the content understand what it is that you want to do with their materials. So now I'm going to go into fair use, which again, many of you may be familiar with already. So fair use, Section 107 of US copyright law, says that using a copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So this is the language that's in the statute. And it is basically saying, and again, this is meant to be the minimum of things that people can do if they can make a fair use case to use other people's content, is to think about um, how you're using this work. So there's criticism, there's comment, news reporting, teaching, there's active engagement with how you're working with this content. So some of you may be using materials to build exhibitions or build other types of work that are telling a compelling story, that are commenting on elements of this material, this content, or that is building a story about something. And so you might want to think about, does fair use apply to what you're planning to do and what your intention is with the materials? We talked earlier about the balance that's there in copyright law. So the balance between users and creators of content. In education, many of us who are, in education, in libraries, in archives and museums, rely on fair use fairly heavily. Fair use for a scholarship, fair use for creating exhibitions, for work and research. These are all things that are elements that are kind of second nature to the work that we're doing. We're working with content that belongs to others, but we're also wanting to engage with it, to be in conversation with some of this content. When thinking about fair use, there are 4 factors, and these factors are stated in the in US copyright law. You can find it in section 107. It goes through the 4 factors are the purpose of the use. What are you doing with this material? And then there is a fairly recent, it's getting to be maybe not so recent, but uh, in the scheme of things, I think it's still safe to say fairly recent notion around transformativeness. And so this is using this content for a completely different purpose than the original author may have used it for. And so courts, when there have been called to question about whether something is fair use, have looked to see, is this transformative? Is this a totally different, maybe unanticipated use of this content? And then for the nature of the work, what type of work is it? Courts have looked more favorably on things that are more fact-based. So, and more favorably on things that are published versus unpublished. But that doesn't mean that some of these things cannot be fair use. But this is where we've seen courts look more favorably. And then for the amount, courts are looking at the quantity and the quality of the use. So, and they're looking at it in relation to the purpose. So, are you only using the amount that you need to fulfill the purpose that you have? And is if that purpose is transformative, that does weigh well or make a good case for you for fair use. Lastly, there's a market harm or potential market harm. So could your use have some kind of impact on the creator and their ability to exploit or make money off of the content that they've created? So would whatever you're doing, your intention, if you're planning to make something available, is the creator also in that same space? Are they doing the same things? And could your use and how you're making the work available have some impact on them? This next one, Section 107, is a right that's available for everyone to make use of. Section 108 is a right that's only available to archives and libraries. Museums are not included for Section 108. And this deals with reproduction. And so you might think of making copies for folks, ILL, making complete copies of content for folks. Section 108 and Section 107 can work together, so you can rely on fair use and Section 108 if you're a library or archive. And the important parts of being able to rely on this is that you are open to the public, and that you are um, not aware of any possibility that there is going to be a or commercial use to this. So the person has asked you to make a copy of something, or they've asked you for ILL, or they've come to you and said that they need a full copy of something. You're able to do this only under certain conditions. And I'm not going to go into all of the conditions that are there, but suffice to say that there are a lot of things that you need to investigate before you can provide a full copy of something to someone. But there is a possibility that you might be able to do that. So if you're working in a library or archive, this might be useful information for some of the work that you might do. Within archives or library collections, museum collections as well, we have content that is impacted by donor agreements. We have e-resource license content. We also have vendors who come to us and wanting to digitize some of the content that we have. So there could be other things that might complicate your use of materials. So if you have things in your collections that might be impacted by what the donor says when they have uh, given this item to you, or it might be impacted by a license, you might want to think about like how you can mitigate those issues or concerns, or if you cannot. If you've made an agreement, let's say with a vendor to come in and digitize some of your works and they've told you, oh, we will clear copyright, we'll clear these other issues, you just let us come in and digitize whatever they want to digitize. Now you want to come and do something else with that material. Would this impact the contract that you have with that vendor that you've said that they could do this and now you are doing it? So you might want to think about that as well. If there's any material that, also might be impacted by e-resources license that you have as well, you might want to think about whether there's any need or concern that could be addressed by what you intend to do. So now we've talked about copyright and the impact of what particular agreements might have, how you might use materials in your collections. I want to talk for a little bit about what's in your collections and why you collect that material. So I imagine for some of you, you're collecting for a multitude of reasons. Like not everything is, an issue or problematic or troubling, but some things may be donor driven or mission driven. And maybe it is for research or education. A lot of reasons why you might come to collect the things that you collect. But when you're collecting these items as part of the collection practice that you might be taking on, you might want to also think about possible intellectual property rights and not just copyright here. So there may be things that have patent protection or things that might implicate or indicate brands or some kind of thing that might be inclusive where you might want to think about privacy and what kind of materials are being collected. If you have material that belongs to indigenous communities or marginalized communities, how might they react to whatever your plans are with this grant and what you intend to do with the digitized content? Would they have concerns about that material and what's happening with it? There are, many things that I'm familiar with, at least a few places that have uncomfortable items in their collections. And then there's the decision and determination of what can be done, what can happen with this material. So the examples that I have here are the records from a twin study. Some of you may have seen this documentary. It's from a few years ago. Three Identical Strangers research project that was done on um, multiple birth families where they separated twins and triplets to test out nature versus nurture, which sounds, very wild right now, but they did it. And these records are now at Yale. So, and not to say like this is the wildest thing at Yale. I'm not saying that, but I'm just, pointing out that there are things that we have in our collections that we have to be careful with. These items, we don't want this material, these records to be made available while people are still alive, where they could be impacted by some of the information that's contained within them. And maybe some of these things are also in your collections as well. Another case that I have up here are these images from Harvard, which contain images of enslaved people. This is one of the images. And then the second image is of someone who is a descendant of the enslaved folks. And she made a claim against Harvard to say that these belong to her. The images belong to her, and she wanted to have them back. And so Harvard had to deal with that, and they're still dealing with that. And so I'm gonna take a pause here to talk. I'm thinking about what we're collecting and how we're collecting things because I know we have the break coming up. So I can pause here and then we can come back to that.
That sounds good. I'll put on the break. If you want to stop screen sharing, I'll go to the break. Thank you. Okay, we're gonna get back. It's 2:49 now, and we'll finish up our presentation. There you go, Sandra.
Sorry, it took me a minute to find the mute button. Okay, so when we left off, we were talking about collections and collecting practices and what it might mean for you and your collections. And so I'll go to the this is my next slide. Still on the same topic of what types of things that you have in your collections, and if there needs to be concerns for you about how you might be able to fulfill the needs of this grant and also fulfill the needs of your mission if you have things that may be impacted by some of the issues that I've highlighted here of why you're collecting certain things, what sort of things might be in your collections, what things that might be of interest of you to you in either preserving, digitizing, making more widely available, and what you should be thinking about in terms of the ability to do that. So some of the things I highlighted before are thinking about, of course, intellectual property rights, particularly copyright, with a lot of the things that you might be wanting to make available or digitize or preserve, but also thinking forward and things that you might be collecting now that may perhaps not be subject to this particular grant or this time, but how you might go move forward in thinking about what you're collecting, how you're labeling the things that you collect, how you're talking about some of the things and engaging with what you have in your collections for items that you have, excuse me, for items that you might have where your organization is not necessarily part of the community. How are you engaging the community in conversation? How are you connecting to them to determine how this work should be dealt with, managed? Particularly, this is important for marginalized communities, people of color, indigenous communities that may have items that are within your collections where you maybe don't have a connection with them. How do you make that connection? How do you talk to those communities, organizations, and groups that might be represented about what it is that you want to do? And then also there's an idea around shared caretaking of this material and content or repatriation of the content and what that might mean. So you are preserving, digitizing this material with the idea of maybe sharing and upkeep and care of this, or sharing with the community to say, okay, we will have a digital representation of this, but we're giving you the physical item back. These are things that are happening now in our communities, in cultural heritage institutions, and it might be something that you might want to think about. You also want to think about how, just because you're digitizing or preserving content doesn't necessarily mean that then that material should be or can be made available online. There may still be a need to have restricted access, limited access to this content. Maybe it's only to the community that it belongs to. Maybe it's only to, if you're at an institution, it's only to the institution, and people have to come to your institution to be able to interact and see this material. But what's important is that you have the ability, you've preserved it, and people, if they want to engage with it, it won't be made available online. They have to come and see it in person. And that might be something that you think about. It might be something that's important for your organization as part of your mission. It might be important for the community where this content represents. So you might want to think about that. Are you willing to do this and have this behavior, have these conversations in some of the things that you have within your collections? Want to move in for the last few minutes to talk about reuse of this materials that you have in your collections and how you might make it available if you have the opportunity or if it makes sense to do for your collection, how you might make it available online and how you might want to communicate issues around rights. Some of you may be familiar, or super familiar with Creative Commons. It is a rights holder solution for a rights holder to be able to communicate with others on how people can make use of their content. So going from the top to the bottom are least restrictive to most restrictive options under Creative Commons. The first one I alluded to earlier, it is something that a rights holder can do, which is to disclaim rights. So you could put this badge on to say, I am not reserving any rights in this content. It is available for anybody to use however they want to use it. And then the rest of the uh, options that you see there are licenses. So from the CC BY license down to the CC BY NCNDSA license, those are licenses that communicate that you can use this content, but you have to use it in the particular ways that I am explaining to you as the rights holder. So someone who may come upon content will say, oh, so this is Creative Commons. Let me go and look and see what non-commercial means, what share alike means, what no derivative means. And so they can make use of that content. So it's important to note here that only a rights holder can use any of these options. If you don't own the content that's in your collections, meaning the copyright, not the physical item, you don't own the copyright in that content, you're not able to make use of these things. So if there's material that's been transferred to you, that these are options that are available to you. If there is content that you created yourself that's a part of the collections that you have, you can determine how you want to make use of that, or your organization can determine how they want to share things for which they own copyright. So there are non-rights and rights holder solutions here on this slide. So this is the public domain mark. This is another badge from Creative Commons where cultural heritage institutions, if they are aware of something, they know that it's in the public domain, maybe it's so old that it more than likely is in the public domain, they can use this mark on things where they are not the rights holder. They did not create the content, but they believe it to be in the public domain. They can use the public domain on that. Again, this does involve, probably doing some research if you're looking for something that's within like the 20th century and you're thinking about like that black hole period that I talked about of 1929 to 1977, where you did the research, you figured out that they didn't do the formality that they need. This work is in the public domain. You might want to see if you could use this public domain mark. What I've seen though mostly is that people use it for things that are very clearly in the public domain. So items from the 1700s, they would, use this mark for. I've seen people be very cautious in using that for items for which they are not the rights holder. There's also the right statement badges that were created for cultural heritage institutions to try to indicate some information about what they've figured out about some of the work that's in their collections. So they have determined that it's in copyright. There's no copyright. There's some other issue that should be considered. And usually with that other category, there's some other determinant that might be of concern. So it might be a donor issue, it might be privacy issues or right of publicity or some other issue that's at play there. But these were created so that cultural heritage institutions, if they've done the research, they can utilize some of these options to try to give some information to people who might want to make use of material that's been made available through them. And then lastly are the local context, which has the traditional knowledge symbols available for Indigenous communities themselves to kind of indicate what material is and what can be done with that material. And there's a section that's available for institutions and researchers who are using Indigenous materials. And this definitely involves a lot of research and making sure that you understand what is covered under this and how you can make things available. It may be that you can't make things available, that you're not able to make things as accessible, even though you've done the preservation work or you've done some part to do some digitizing to try to save content in some way. It may be that the answer is not that it can go online. Maybe it still becomes that people need to come and see that material in person. So I have reached the end of my slides and the things that I wanted to formally talk with you about today. So now I think we're okay to open up for questions.
Yeah, sounds good. It's question and answer time. It looks like we have about 7 or 8 that have already been submitted. As a reminder, please submit your questions into the Q&A box so they don't get lost in the chat. The first question for you, Sandra, is life of the author starts at their death? That's the question.
Yeah, I know it sounds weird where I'm like, life of the author plus 70 years. So yeah, No. So, and I'm sorry, I maybe spoke too fast through that, but it is essentially that the person lives their whole life, they die, and then 70 years after they die, that is when the thing that they created, whenever they did through their lifetime, that is when that item goes into the public domain. So the author has their life, however long that is. You know, people are living to 100 now. And then 70 years after that, whatever they created goes into the public domain. So to think about it, when I started, we talked about how with the Statute of Anne, life, it was 14 years, and then you could renew for another 14 years if you were still alive. So what that indicates to me is that that was a right that was for you. So now the right is for you and also for your heirs, and maybe even several generations of your heirs to benefit from something that you created.
Next question is community meeting archives. Does the board own the archives?
Community meeting, what does that mean?
I'm not sure. Whoever put that question in, if you want to expand in the box now or the chat. It
So
said, I guess it's the reference to what you said earlier, where it says community meeting archives. Does the board own the archives? That's the question.
so I don't know who the board or the community is. So I'm gonna take it, and if this is not correct, please feel free to type in the chat or in the Q&A, or if this is not correct. But if I'm reading it as there's an organization that has a community archive that's not necessarily created or owned by the board.
So yeah, they said in the chat, yes, the Cultural Committee Center archives contain meeting notes.
For the community center.
Yes.
So those are likely created for the benefit of the community center. So then the entity would be the owners of those notes. Yeah. So I was starting to answer it like it was not related. So thank you for clarifying. So yeah, so if it is the organization's meeting notes, those are being created for the benefit of them. Whoever is writing them up is doing it for the institution. So the institution would likely be the author of that.
Thank you. Thanks for this session. We have archival material created by the U.S. government, which contains some identifying information, address of business, people's age, and distinct physical characteristics. How to square copyright or lack thereof with privacy with use.
Oof. So yeah, so this is not necessarily a copyright question. It's definitely, you hit it as a privacy issue. So I think there's the ethics part of that is if it's of concern that it has things that could personally identify people who may be still alive, what is that content? Is it something that they might feel is detrimental to have be made available? I think there's definitely a difference between the address of a business and someone's age, or description of them. So you might want to think about, like, is it important to have that? Is there a way for us to de-identify or to suppress that information? But yeah, it gets to a different question related to privacy. And it definitely is something that, you might want to think about, like how you make that available, even if it's possible that whoever might be impacted is no longer alive. Do they have family or an estate that might be concerned about this content being made available about them, especially if it's easy to identify particular people? Would there be an issue or concern for them having this content out there? If that's in the intent, it might not be an intent for you to make it available online, but that is something that you want to think about.
Next question, creating an online exhibit or a physical space, or maybe that's of a physical space, are the copyright factors the same?
So what's different here is in the face-to-face thing. So an online exhibit is not face-to-face. It is available for everybody who's able to access it online. In a physical space, you do have a lot more leeway because you can do some things, you can do things because only the people who come into that space are able to actually see and engage with the content that you've made available in the physical exhibition. Now, things to think about here too, even with a physical exhibition, is creating a catalog. So creating a catalog of content that appeared in the exhibition gets closer to doing an online exhibition because the audience becomes bigger with you creating a catalog that could go beyond the space that you might have held something. So you might be thinking about like the fair use factor. So if you're relying on fair use to make copies or to distribute content, then that now you want to think about like, so now my audience is much bigger than if they were coming to my facility to see this. If it's online or if it's in a catalog, you want to think about, does fair use still help me, still make sense for me to rely on, or does it make more sense for me to try to get permission to include certain types of content? So you want to make sure if there are things that are still covered by copyright that you're able to make a case either because you got permission from the rights holder to be able to include that content, or you're able to like work through fair use to determine, okay, I think that, you know, we're good if as we work through those 4 factors. And again, when you're having it in a space that's beyond the physical place, so either online or through some other network or way you might be distributing content, you have to think about those 4 factors: the purpose of your use, what is the material, nature of the material being used, how much of it are you using, and you know, is there a engagement in relation to the purpose, and then whether there is an impact for the market of the person who created that content. So if you put it into an online bulletin, you put it into a catalog, would that create competition for the rights holder? Would there create some issue for the rights holder to be able to also be able to make money? That should have an impact on how you're thinking about it.
Wonderful, great questions. If an archive meets the requirements of Section 108, can an archive make the copyrighted content publicly available on their website?
This is a great question, and thank you for asking it. Section 108 is about copies and how you distribute. So making it available online is not one of the things that it is specifically geared towards personal research and study of an individual, or in some cases under Section 108, another library or archive. So you want to think, you would, if you are thinking about how I have a copy or I can make a copy for something, you might have to think about whether fair use would allow you to be able to make it available online. Sometimes you can't, the fair use case is not that great, and so maybe it doesn't make sense to make it available online. But just because you're able to do preservation to make a copy for someone for research or study doesn't mean then the access could become or be wider than that necessarily. You definitely want to see whether or not you can make an actual fair use case, or allow someone to, with their copy, make their own fair use case or get permission to be able to do something beyond just making that copy.
Good. Some of our digitization partners are concerned with getting permission from the heirs or descendants of the record creators of the archival collections that have been selected for digitization. Can you share cases where this would be good to do? There's a mixture of copyright for these collections. Some were transferred to the institution and some retain the copyright for the individual record creator.
So I would never say that you shouldn't get permission or try to get permission from someone, but I am aware that you might not be able to. So for reasons of folks just not responding, or they're not interested, or the answer is no, but they don't want to tell you no, you might not hear back from folks that you reach out to regarding the work of their the person that they are a descendant of. And so excuse me. you want to think about like what is the possible risk to try to make things available. You digitize this material. If you have a case where it's something that is falling apart, you need to do something to intervene. You need to preserve this content. The preservation part, I think you're on good grounding to be able to preserve it. But I know for some of you, if there's interest in now we've preserved it and now we want to make sure people can access it, or we want to have a way to provide access. And it's not necessarily the case that um, copyright law can necessarily get you there. So some other things that you might want to think about is, would there be an issue from a descendant or an heir if you decided, okay, we've now preserved and digitized this work, we want to make it available online? Would somebody from the family or their estate come forward to say, no, you can't do that, you need to take it down? Would they do something, through social media or in person to say, hey, this organization is doing this and we said no, we didn't want them to do it? And you have to think about that risk of, is that something that you want to engage with or not engage with? So there are, I think you should always try to get permission if it's important for you to do certain things and you're not sure that you have that right, or you're not sure that copyright law covers what you're talking about. If you can get permission, you should try to do that. But you definitely have to be prepared. And I know some of you probably on the call are well aware that you sometimes can't get into or in touch with the people who could give you permission or could weigh in on what you're planning to do. And so I'm not saying, you're just stuck and you can't do anything, but you do have to think about what the possible risks are with, if you want to keep moving forward with an action, to be prepared for a reaction or a response that may not align with what you want.
Great. There are two. Okay, this next one, related to privacy concerns. In our collection, we have materials from a community that has expressed concerns about revealing information about undocumented individuals and families. This isn't a rights question, but rather an ethical one. Are there guidelines available for navigating this?
So I don't have guidelines for this, but I think, you do have to listen to the community, right? And I think it is important and imperative to listen to folks who are expressing to you that this is an issue for them. Because I think you want if it's a community that you're working with and you want to continue to work with, if you decide to move forward however you would like to, um, without taking into consideration what the community wants, I think that challenges your ability to continue to work with them. So you want to think about, like, what does it mean to keep this information in because we think it's important to be in? Um, is it important to the story that you're hoping to convey or display? If it's not, then you need to think about how you can share without that information being shared as well, or if you need to remove certain perspectives or certain parts to be able to honor that request.
These next two are probably more program officer oriented, but Sandra, feel free after I respond to maybe give your input on these. And also in regards to what you just spoke about, maybe referencing professional practice guidelines produced by museums, archival, or library organizations would be also recommended in that case. The next question is, we received excellent feedback in our initial application to fund the creation of a governance group with the grant to inform the accessibility of our digitized collection. Is it okay for our organization's access plans to shift based on the expertise of this governance group? This might be okay, but it's important to outline in the proposal any issues that you anticipate arising and how decisions about access will be made by the group, including the options you anticipate offering, be they total restriction, access on site only, limited online access, full access to part of the materials, and restriction on sensitive items, etc. And if it seems that if it seems to reviewers that you have no idea what the issues that might come or arise that might damage the competitiveness of the proposal. Did you want to add anything to that, Sandra, as a former reviewer?
Yes, I just wanted to chime in to say that when I was looking at some of the grant applications, I'm always kind of looking to see if there's an acknowledgement that there are copyright considerations, there are ethical considerations, there are other things that they are thinking about in terms of doing this project, and then that they have a plan of action. So, I definitely want to see that that there's something, and that you have something set up. You're thinking about how you can address it. I always kind of, I don't want to say ding, but I would give, kind of lower scores to applications where it didn't feel like they even recognized that there was an issue around legal issues, there was any issue around either cultural heritage, privacy, like there's no acknowledgement that there's something to be concerned about with the material that they're working with. And then they definitely didn't have a plan. I would give lower scores. So I just want to part of my wanting to do this work was to just talk about like what you should be thinking about if you have anything that's in your content that is of concern. You need to be able to show like this is how we're planning to mitigate that, manage that, or we have already been in contact with, the heirs, we have their permission, we are planning to do this, we're planning to restrict it, whatever the case may be. I want to just to reiterate to say that you need to have something in place that that shows that you've been thinking about it and you have a strategy.
Perfect. That is correct. There are some complicated questions in some of our materials regarding copyright. Is it possible to include funds for a copyright consultant in our grant? If so, are there recommendations available for legal consultants? And as a program officer, I'm gonna say, no, this is not recommended or fundable, unfortunately. It's not an allowable expense with the budget. An advisory group may offer some input on ethical considerations, but applicants are expected to outline the copyright issues at play in the proposals at the time of submission, just as Sandra elaborated on previously. Did you want to add anything to that, Sandra? Good. Okay. Can you explain copyrights for correspondence? Does each sender or recipient retain the rights to their side of the conversation?
Yes. So this is considered unpublished unless people do publish the letters at some point. But yeah, it's an unpublished work, and the person who they retain rights for their part of the conversation. So if I write a letter to Sharon, I have the copyright in that letter. Sharon has the physical letter, but I still have the copyright. So if Sharon decides she wants to donate it to her alma mater, in order for somebody else to make use of it that's beyond fair use or beyond some other statutory allowance, they should come to me to get permission.
Next question is, we want to make our collection accessible online, but we are concerned about the unauthorized commercial reuse of the collection. Since we do not own a copyright and cannot ask every creator for permission to share online, what are some strategies for balancing access and preventing unauthorized reuse?
So some strategies you may see from other cultural heritage institutions, libraries, archives, and museums who make content available, content where they do not have permission, and many of them are relying on fair use to be able to make that material available openly online and saying it's for scholarship or educational purposes. The One of the things that I would highly recommend doing is whatever information you have about this content, you may not have much, but you can have language that says this material may be covered by copyright, that people need to contact rights holders in order to reuse content beyond scope of fair use or beyond any other kind of statutory exemption that might allow them to reuse it. So you want to have language that tells people this is covered by copyright. It's not our copyright. But if you want to do something beyond just looking at it here, you need to make sure you either have permission or you have a fair use that you're able to rely on to make another use of that material. So as things kind of go these days where we have AI large language modeling, a lot of, AI training. We now, as cultural heritage institutions, it's hard for us to then control what people do or how people are able to make use of things that we put online. So some things are beyond our control, but you can have language that talks about the fact that this content, you're making it available under fair use, or you're making it available with permission, or however you're making it available. You can have that language there to say, but if you try to do, you public who's come to this website, you try to do something different than what we have made this available for, that's on you to figure out how you do that. And so you can look, I would recommend looking at different examples of cultural heritage institutions that have, like, big, large corpus of content available online, and see what language they use to make that material available, and how they talk about copyright and how they talk about reuse, and kind of model that language for your use to see how that might work for you. Sharon, you're muted.
I thought I hit the button. This question isn't specifically related to this grant, but related to copyright. I've often wondered if we have historic photographs, for instance, that have entered the public domain. Can we still legally or ethically charge a use fee for or licensing fee for them, even though they're in the public domain? I assume not, but that the user should still credit the image to our institution.
Okay, so there are a couple things here. So I'm glad this is still up on my, so let me look at this. So even if this work were still covered by copyright, for you to provide a copy to someone, and let's say if you're a library or an archive and you're relying on Section 108 to provide a copy to someone who's made a request, you can charge for that. So the US copyright law doesn't consider cost recovery as a commercial activity or a commercial practice. So for content where it is in the public domain means there are no rights attached to it. So whether ethically you talk about whether you should give it away for free or not, it's up to you. But legally, if it's in the public domain, you can do whatever you want with it. Now, talking about citation practice and citation, which is a something that kind of moves in tandem with copyright, but is not copyright. So there are citation practices around, you have found something in an archive, and so you cite, for the thing itself using whatever citation system or method makes sense, or whatever's the norm for your practice area. But there are parts, especially in archival practice, where you acknowledge or have some statement about getting something from a particular place. And so that is part of the practice, to say that it's come from this place. There isn't a legal obligation to do that necessarily. But with citation, it is an academic expectation. It is, some would even consider ethical expectation that you would give credit to where this thing came from. And for some, that includes the institution or the repository where you may have gotten something to, or gotten access to something. So to make copies of things as cost recovery is not considered commercial activity necessarily. If you're having things where it's in the public domain and you're making bags and buttons and selling that, whether you consider that to be ethically not great, I don't know, but it's not illegal to do. Now, of things that are still covered by copyright, if you're making bags and t-shirts of still copyrighted content, and there's also a rights holder that also wants to make bags and things, that's probably impacting their ability to like exploit the thing that they created, and make money off of t-shirts as well. So if that person is still alive, if their heirs are still alive, that might be something where you would contact them and say, hey, here we have an idea, can we partner with you to do this? You split the, income or whatever it is you do, but that's something where you would, if it's in copyright, that makes it a little different.
Okay, we have about 4 more I'd like to get through. One is a program officer response. Our collection and holding institution is in Canada. Do we need to explicitly refer to the relevant and equivalent sections of the Canadian Copyright Act to the US Copyright Act in our application? So in your case, the Canadian Copyright Act would apply. Canadian law is based on some of the same principle, but is different in meaningful ways regarding fair dealing and fair use. So that was an easier one. Okay, the next question for you, Sandra, is a producer, poet of poetry, jazz, live recordings just passed away yesterday. He deeded the physical reels and audio cassettes that contain over 100 musicians, but he did not secure releases from the performers. We would like to create online access to some of the recordings that have national and area musicians on the tapes. Would the right statement badges work for online access? I believe the Library of Congress uses disclaimer statements and puts the onus of copyright on the researcher.
Yeah, so the disclaimer statements is kind of what I was referring to earlier in the question of, how can we make things available online? So, and this gets into kind of a risk analysis as well as, kind of dealing with copyright and all the layers of copyright, especially for music. So because you have sound recordings, you have the performer, you have performer rights, you have then the music rights as well. So there's a lot of stuff that's going on with this. So I think for institutions for whom, there's interest in making this content available, you have to think about what happens if somebody says that they want this taken down, or they want to sue you, or they want, some kind of payment for having this material. Like, what is your response to that? And think about what that means for you or your institution. So, not to um, I'm definitely not trying to be shady, but the Library of Congress, is the Library of Congress, and they can work with folks, or they also risk being sued as well. But people are probably not going to sue. They might try to work something out with the Library of Congress and with their things. And you might want to think about like what that might mean for you as a different kind of institution. So what does your language say about how people can engage with or access this content? Would it make more sense for people to come into your space to be able to hear and listen to this content? Would it make sense to do, short snippets to have that available, and say, if you want to, hear the whole thing, you need to come into our space to be able to engage with it. You have to think about like what the risk versus, what the mission is, and what that conflict might mean for your institution. And unfortunately, I can't tell you what you should do, but there are a number of things that you might want to think about.
Thank you. 2 more. We will be digitizing newspapers from 64 to 74, 1964 to 1974. Many of these articles have work for hire authors. Does this change how we might want to be thinking about copyright in terms of the life plus author rule? And there was a follow-up question to the same question that says, are newspaper articles in a scrapbook under the same copyright issues?
Oh, you guys are coming with really great questions. Okay. So 64 to 74 falls into that black hole period of where you would want to research to see if that material is still actually covered by copyright. So it is possible, with a newspaper, unlikely, but possible that they didn't follow whatever formality was in place during that time period, and maybe that work has gone into the public domain. But you would have to do some research to figure out if that's true. If you wanted to just scrap that and just operate as, let's just go with it's still covered by copyright, then you're right to think about whether the articles are considered work for hire. Things with newspapers to keep in mind is that they often carried stories where it wasn't done by their reporters. They may have done wire service articles, so you have to think about that. Then that's not work for hire. That is something that they contracted to include in their newspaper. So you have to think about that, and whether that article then belongs to the author or to wherever that article may have originated. So you have to think about a little bit more sometimes with newspapers. So And then if there is content that where the newspaper is the rights holder, then you're thinking about institutional copyright. So that term is different. So it is 95 or 120 years. So you have to think about when it was created and whether the institution is considered to be the rights holder. And then in terms of newspaper articles in a scrapbook, so there's still copyright, but what makes a scrapbook a little bit different is typically with a scrapbook is someone cutting out different parts and different elements and putting together these different things to tell a particular story or to capture different elements or different parts of things. And so sometimes you can look at that and think of it more of a compilation, and you might want to think about whether fair use might apply to you being able to digitize and make that work available if that's possible. So you want to look at it as a different kind of thing where someone has like built up this scrapbook using different elements and different things that they've taken from places, and looking at it more from a fair use perspective and whether fair use would make more sense for you to think about if you can digitize it, and then what else you can do beyond that.
Okay, we have one last question. Our collections have a mix of materials that people collected over time as scholars, i.e. pamphlets or flyers, which have various, sometimes unknown creators. If the attempts are made to track down the creator, can we claim that we did our due diligence?
So the unknown creators or unknown, date of creation, those things are often called orphan works. And so it might be difficult to try to figure out who actually created a thing. And this actually could be the case with a lot of things. So it could be photographs or even books could fall into orphan, where yes, it was published by a publishing company, but the publisher has gone out of business, and you haven't found that anybody succeeded them. Or you have a pamphlet that was made for an organization that's now defunct. No organization succeeded them. Who should you reach out to for permission, or is there even anybody to reach out to? Something that was created for a short-term event that now exists as part of a collection, you don't know who to ask to get permission for that. So I know that many of these things, these orphaned things, there is a certain element of due diligence that you can try to do, and then you can document that to show like we try to like retrace who should be the person to reach out to, and then it becomes many things do kind of turn into a risk analysis to think about. So who would be harmed if we try to use it in these types of ways? Who might come forward to say something about how we're making this reuse? And in some cases with some orphan content, nobody's going to come forward. But in some cases, it might surface folks who are like, oh, wait, I know something about this. I have information about that. Or this was created as part of this thing. And that could actually be used to kind of build and have more context and information for the thing. And it could be part of relationship building, or it could turn into something where someone's like, I know that belongs to me, or that's my thing, and now I want to talk to you more about that, which could be good or bad. But I think there's still, there's definitely in any of these instances where you need to do research showing how you've tried to find more information, try to find the appropriate rights holder, try to find out more information about the content, only helps, in cases where you're saying you maybe copyright doesn't exactly help you out here, or there's no person to get permission from. It just helps with those cases.
Wonderful.
All right, we have just a few quick reminders before we end. First, we want to do a quick check-in with you again about today's topic. So we'll launch another poll now. And if you can take just a moment to complete it. And as that poll is wrapping up, as you work on your final application, Remember that there'll be 2 additional sessions over the next month. The next one will be on April 10th, and we'll address staffing and budget. And you can sign up for this session on our Apply for Award page. And finally, we're so glad that you were able to join us today, and extend a huge thanks to Sandra for leading. As we continue our assessment of the program, we appreciate your continued feedback. We've shared the link to the survey for today's webinar in the chat, and we look forward to hearing how this session went, what you might like to see in future sessions, and how we might improve. Please don't hesitate to send questions to the Clear Grants team at hiddencollections@clear.org as they come up between now and that final submission deadline of May 8th. And as needed, our team will also be able to reach out on questions specific to today's topic. Thank you, and we hope to see you at another session soon.